So should we just do introductions first? So I'm Ash, I'm head of Pebblebeach Fundraising. We're an agency in Brighton and we do lots of fundraising for lots of charities. And we are constantly engaging and working with our charity partners on issues around audience, privacy, GDPR, ability to communicate with supporters. And it's something that we come across in every campaign that we do, and it's an issue for many of our clients. I'd like to introduce Phil and David from Data Protection People. These guys, I first met you, David, I think it was about sort of 4 or 5 years ago now, wasn't it?
It was whilst I was working in the hospice sector myself.
That's right. Okay.
Francis Hospice, yeah.
Yes, you were working in the hospice, and I went to one of David's sessions when GDPR was just coming in, and sat there and realised that even though I've been in fundraising for 25 years and think I know this, actually I really, really don't know what I'm talking about when it comes to data protection. And so when Pebblebeach was looking to review our processes and our structures and make sure that we were handling data properly and make sure that we were complying with GDPR and also able to give best advice, we turned to Data Protection People for advice and support. So these guys have been working with us to help us as an agency make sure that we're compliant and that we understand the rules efficiently and effectively so that we can advise our clients. So when we've asked our clients for various, our charity clients for various things that they'd like us to talk about on a webinar, data issues and data protection came up constantly. So that's why we thought rather than us talking about it, it makes absolute sense that we're here. So guys, do you want to say hi and introduce yourself?
Yeah, for sure. Do you want to go first, Phil?
Okay, yeah, I'm Phil Brining. Thank you, Dave. And I'm a director of the consulting operations at Data Protection People. I've been doing data protection for, I would have thought, 15 years, but I have a rich and colourful background in my career, working in hotels, publishing, professional sport, charities, and a whole host of other places. So I kind of get the operational stuff because most of my career has been operational, but I absolutely love working with this branch of the law. It's absolutely fantastic. Dave.
Go on, follow that.
Hi, I'm David. I am a senior consultant for Data Protection People. I've worked with Phil directly now for probably coming on about 2.5 years. Prior to that, I worked in the charity sector in direct marketing for St Francis Hospice in Romford, and we still keep key relationships, or I still keep key relationships with DPP with some of the contacts that I made within the hospice sector to help them through their compliance journey with the GDPR. And making sure that the measures that they're deploying for effective communications meet the requirements of the GDPR and enable them to fundraise in a more effective way.
Sure. Okay. Thanks, guys. Okay, so what we're going to covering on the slide that you can see. So we're just going to touch on the benefits of getting it right. Why should we be focused on this, and what's important about this, and what does it enable us to do, and some of the common pitfalls and problems. And Phil and David will talk through an overview of GDPR, what it is, what it isn't, and also then crucially how GDPR relates to fundraising activity. And then we'll go through some of the key questions and then answer any questions at the end. I think that just the starting point for this is that the background we're all in is that our experience has been that where a large charity has got the ability to put the dedicated resource into understanding and implementing GDPR, then that's mostly been successful. We work with a lot of smaller and local and regional charities that don't have that level of resource, and we've seen there's been a huge variation in understanding of and implementation of GDPR regulations as they apply to charities. And many times decisions that have been taken have created issues and problems. Because sometimes it was the person who doesn't have responsibility for raising money that has made decisions about how data is used and how the charity is allowed to communicate, that there's then created a problem. And so often our relationship and our responsibility is helping charities to solve problems. And that's what I'm hoping this session is, that we try and provide practical guidelines and routes to saying, if this is the problem, if this is the situation you're in and you want to change that, here's a methodology and here's a strategy for how you can do that. So it's all going to be thinking about practical application. How do we actually use GDPR? How do we make sure that we adhere to the law, that we adhere to policies, but we allow ourselves to fundraise? And particularly in this moment, the way I describe it is, it's all fine having our data segmentation and having our policies and privacies, but actually, if suddenly the roof burns down, then we just need to go and ask everyone that's ever supported us for money, because it's a crisis. Well, all of our roofs are on fire at the moment, and therefore we don't need to be in a situation at a time when charities are facing, huge shortfalls in income. We don't need to be facing a situation where, because of some misapplied regulation or understanding of legislation, that charity has to suffer huge income losses and is not able to go out and actually communicate its situation to the market. Okay, so moving forward, so the benefit of getting it right. So direct marketing. So the vast majority of our work involves direct marketing to a charity supporting audience, and as it says, their audience always comes first for us. So the very first conversation, and for those of you that have worked with us, you'll know how boring this gets, is that the first question I will always ask you is, right, audience, data, come on, what have you got, who have you got, and what is your GDPR policy and what is your privacy policy? And it is those questions that always comes first. And the reason for that is because, as I'm sure you know, for any fundraising activity, 80% of the income will come from 20% of the audience. And therefore, it's about understanding who is that audience, how are they likely to respond, how can I communicate with them? And what we constantly see with GDPR and privacy policies is that decisions have been made that don't understand the impact and effect on our ability to then speak to the right audience in the right way. And so our role is to provide data analysis and understanding of a charity's data set, and to use experience of past response from other similar organizations to be able to predict who is likely to respond. And it is extremely common for us that we will encounter a rule or a barrier to communication that allows us to communicate with a group of individuals who are almost certainly not going to be profitable for fundraising, but disallows us from communicating with a different group of individuals who almost certainly would like to give lots of money. But the rule or the policies have existed that deny that. And of course, the results are a better return on investment. So rather than simply having a blanket approach to data selection, being able to sensibly understand the relationship between the charity and the audience, and then be able to communicate in the right way, that's how we maximize response. Okay, so the challenge for us is, right, we would like, particularly in this situation, particularly in the midst of a pandemic, we want to be able to reach out to everybody. And I'll give you an example of why. A campaign that we recently produced and delivered about 3 months ago, in the height of the pandemic for one of our clients, we looked at their audience, their donor base. And we have a predictive model that expects a certain amount of income from us from a database of that size. We then use that information to create a data segmentation for the campaign, and we sent the campaign out. What we got back was 5 times the expected response, was 5 times the level of normal income that we'd expect for a appeal like that. And what it meant was that had we actually applied that new understanding of higher levels of income to the whole database, pretty much everyone would have been profitable for that one. Okay, but there were rules in place that meant there were significant sections of that data set that we simply could not access because a decision had been made 3 years ago that prevented that from happening. And so all the evidence is there that people will want to respond, particularly in these times, particularly more historic donors. Again, often the challenge is people who haven't supported for a number of years are non-contactable, but yet where we are able to contact them, we get very strong response from them because we're able to talk to them about the need, the problem, solution. So that's where we're starting from. So if we look at the first thing, so guys, can I ask you to sort of lead us through this slide? So we're looking at GDPR overview. So what is GDPR?
Yeah, thanks, Ash. I'll just kind of take this briefly and then pass on to Dave to explain how it kind of works with the objectives of fundraising. So for GDPR, everyone will know it stands for the General Data Protection Regulation, which is law in the UK and Europe, providing a framework and regulating how information relating to living people is processed. I always remind people or advise people that the GDPR has got two stated objectives. One is the free movement of data. It's not designed to stop things happening. It recognises commerciality. It recognises that the European Union is a big market, and it's not designed to inhibit the transfer of data or the processing of data in that market. If you think about it, it's shooting itself in the foot if it's designed to try and stop things like that happening, and it's not designed for that purpose. But his second objective is to uphold people's rights to privacy and certain rights in respect of their personal data and how it's managed. So you got to always bear that in mind. What's the objective of this law? It's designed to encourage the free movement of data and provide a framework for the free movement of data whilst upholding people's rights. And the GDPR, this is really simple in my view, as a real high level overview. The 7 principles that within it, fair, lawful processing, for specified processes. You can't collect too much data, there's minimization, you've got to keep it accurate, you can't retain it for too long, you've got to maintain it securely. And you're accountable, being able to demonstrate how you comply with those prior 6 principles. So there's 7 principles within it. People have got certain rights that are conferred on them by law, the rights to information about how the data's been processed being one of them, the right of access people are aware of, the right of erasure, so on and so forth. So there's rights that are set out in law that are enshrined. They're not all absolute rights. They're not all. If somebody says, "I want you to raise my data," that's not an absolute right. It's conditional. So these rights need to be understood because they're not absolute. There are a couple of absolute rights which we'll come on to, but most of them are conditional. You have to assess whether they apply in the specific case. So there's the 7 principles. There's the rights. And then there's obligations that the likes of us have got to comply with, organizations who are processing personal data. For example, appointing a data protection officer, undertaking data protection impact assessments, reporting personal data breaches, managing data processes if we appoint people to process on our behalf, rules around transferring data overseas. So those obligations are also set out in the law. There's a couple of woolly ones which are, I think, going to be more important going forward, like the principle of data protection by default and by design. What does that mean? How is that embedded in the processing activities? But overall, the GDPR is the law across Europe, and if you think about it, it applies to all organizations posting data across the entire continent, or 27 member states to be more precise. It's drafted fairly broadly. That means it's open to interpretation. If you think about it, it applies to all sectors. The health sector, the commercial sector, the charity sector, the other members of the third sector, like religious organizations. It's designed to be broadly drafted, and therefore we have to try and interpret it, and that's where the wheels start to fall off, because as soon as you start saying to people, you've got to interpret, this word necessary, what is necessary, what's proportional, which is a type of language the GDPR uses, then everyone's got a different point of view, and some people have got a vested interest in making you understand, what they want you to understand, and that's why back to Ash's point, people have reversed themselves into cul-de-sacs. It's often because they've had some duff advice from somebody who's got a vested interest. So in summary, the 7 principles, rights, obligations, it's the law. We have to comply with it. It is open to interpretation. The key thing is building a defensible position if you think you're in a bit of an edge case situation. I don't know if that's too high level or too detailed, but that's really GDPR in a nutshell.
I think it's helpful, and I think that general principle is that when these rules arrived, I think there were quite a few people that did see them as there was this grid of laws and rules by which you must abide, and if you didn't abide by them, then you would be locked up in the hole somewhere, and your charity would be fined hundreds and hundreds of thousands of pounds. And the famous cases of Red Cross, for example, being fined because of misuse of data really panicked a lot of the charity sector, and therefore your point about decisions were made, and often it's been decisions made by people who do not understand the legislation at all, that have had to come in, and they've taken a very overly cautious approach often.
Yeah. Now, there's just something else we need to touch on, because the GDPR is that, but there's another piece of legislation that we will definitely bump into when we're doing direct marketing, which is the Privacy and Electronic Communications Regulations, which is referred to as PECR. So if we start talking about PECR, we're talking about the privacy and electronic communications regulations, and they are again a very broad set of a very broad piece of legislation which replaced Telecommunications Act. So it regulates telecoms companies. It regulates things like directory services, interception of communications. But tucked away at the back end of it, there's a regulation about doing direct marketing, unsolicited direct marketing using electronic means. Electronic means being emails, telephones, social media, websites, the placing of cookies. So those regulations are also really important to understand.
Sure.
Again, they're woolly, they're open to interpretation. I think in some cases the ICO has got it wrong when it relates to charities, but that's only my opinion. So we'll be talking not only about the GDPR, but also about the PECR as well.
Okay, fair enough. And at the bottom there, we talk about data processing agreements. So we've worked with you guys on a DPA that we now share and apply with all of our clients. So in a nutshell, what's a DPA and why is that important?
Well, one of the obligations on data controllers, that's the organizations who are controlling the processing of personal data, which to all intents and purposes would be an employer, for instance, so they're controlling the processing of their employee data. Or one of the obligations on data controllers is that if they subcontract out processing or appoint somebody to process on their behalf, Article 28 of the GDPR says you must have a specifically structured agreement in place to regulate that processing. So
Sure.
a data processor agreement. It's a bit more relaxed when you're sharing data with another organization who is also kind of controlling that data, and it only, you don't have to have such stringent measures in. But basically, if you're disclosing data to another organization or a third party, you need to have some kind of paperwork in place. If it's a processor, the law specifies exactly what needs to be in there as a minimum. If
Sure.
it's another controller, it's a lot more relaxed because the controller is caught by the entirety of the GDPR, whereas a processor isn't.
Sure.
And just to put that in a fundraising context for yourself and people who are listening, if you're working in the fundraising arm of a hospice, for example, you will need data processing agreements between yourself and a print and mailing house, or yourself and an agency like Pebblebeach, who you're working with for your processing activities.
Yeah.
So you will be expected to use them.
Sure. Okay, should we just move to next slide? So again, GDPR, David, I think this is your moment to shine, isn't it? So your background as working in charities, obviously you've seen this from both sides now. So how does GDPR, again, in relation to fundraising, what are the key points we need to be aware of?
Yeah, for sure. Fundraising and fundraising communications are caught by the definition of direct marketing. The strict definition of direct marketing is contained within the Data Protection Act. It was in the old Act of 1998. It is now in the new Act. It's been carried across. So it's in Section 122, subparagraph 5. The ICO, however, have padded out that definition to include and to be explicit that it includes charities and the not-for-profit sectors. So direct marketing isn't just a commercial activity. So it will capture fundraising activities and fundraising communications as direct marketing.
Okay.
In that sense, the Information Commissioner's Office, pursuant to their requirements under the Data Protection Act, have to publish a code of practice on direct marketing. There is an old version out there. There was a new version that went out for consultation that has since closed, so it's still only in draft version. The official copy hasn't been yet published, but I would urge anybody to pick up a copy and to read through and to see what it actually means for you, because it is a statutory guide. It's in the law that the Information Commissioner publishes them, and therefore the Information Commissioner's Office will be referring to them if there's any investigatory requirements into the activities that you've been undertaking from a fundraising point.
So is it reasonable, I mean, Phil, in your opening remarks there, you talked about the fact that what it is and what it isn't. It's about allowing flow of data and communication. It's about enabling that conversation between interested parties. And therefore, for charities, the rules are not designed to prevent fundraising. The rules are simply there to say, actually, this is a legitimate conversation that charities can have with people who support it and people that might be interested. But we need to do this appropriately and sensibly. Yeah, it's not a barrier.
Correct.
It's a
Correct,
guideline
yeah.
to how it takes place. Yeah?
Exactly. My opinion is that the law provides a framework for you to enable that to happen. Whatever your business activity is, the law provides, when it involves processing people's data, the law provides a framework that you have hoops to jump through in order to make sure that you're doing that in a responsible way. So it's not there just to stop. There are some hard stops. So, you know, because it's also got this dual edge of upholding people's rights. When somebody says, no, I don't want to hear from you, then often, you know, that is a hard stop. You know, you got to respect that. You can't try and wiggle your way around it.
Yeah, sure.
But in the main, you know, for the majority of people, this is just setting out, well, if you're going to do this, then you got to tick these boxes. If you want to do that, you got to tick these boxes. If you can justify your decision making through contemporary evidence, through periodic checking that things are still as you thought they were, then again that adds much more weight to your position if you ever do get challenged.
Okay, I always describe the GDPR and the framework that we implement with organisations as being a safety net. So it's certainly not an inhibitor. Yeah. Like Phil said, there's certainly some points where you do hit that full stop. You can't move any further. Otherwise, what you're trying to do is build a defensible and justifiable stance, which is your safety net. Why are you taking that particular course of action, and can you demonstrate why you've taken that in light of what the law is asking you to do, and have you interpreted the law correctly?
Okay, good stuff. Right,
I think just say that in my experience, probably Dave's as well, most of the organisations we work with don't fully comply with the GDPR. In many respects, they're miles off. They're still on that journey. It's going to take absolutely years, I think. Like health and safety law, before, you know, in the dim and distant past, you know, it was one of those things that was, you know, not as embedded as it is in cultures as it is now. And I think that it'll be the same with this. It's an evolving journey, and if you're not compliant, don't worry, you're not the only ones.
Yeah, absolutely right. Yeah, and I guarantee you, for everyone listening and watching this, whatever your particular situation is, I guarantee that all three of us have met people that are way in a worse situation than you guys. Yeah, so please don't worry about it. So let's look at these individual questions then. So again, most commonly, so for mailing campaigns, so do we have to use consent for mailing campaigns?
The straight answer is, for mailing campaigns, no, you can use legitimate interest.
Okay.
I think we need to be clear what we mean by mailing.
Yeah. I was just going to set that initially, because when I worked in the charity sector, it was at the time Olive Cook, the issues with Olive Cook and the fundraising activities at that point that led to the fundraising regulator being born in that kind of sense. So there's all that kind of going around, and at the same time, everybody suddenly went, we need to go to consent. And I think the RLNI, although I might be wrong, led the charge with going to a full consent model. And then I think everybody kind of looked and kind of went, that must be what we need to do. And everybody suddenly jumped on the bandwagon without actually thinking, well, what are we doing? What do we mean by mailing campaigns? What are the obligations, and what processing activities are we doing around that? And what options have we got? Let's not just go straight to consent. What options have we got? And then to understand which works best for the organisation. Certainly not saying you can't use consent, but consent's a little bit more restricted than if you were using legitimate interest for
Sure.
several reasons.
It's a lot more restricted.
Yeah. So we've used the phrase legitimate interest there. So obviously that's something that we work with, you know, sort of every day when we do this. So what is legitimate interest, and what are the kind of definitions of that?
It's a good question. Let me just set the scene a little bit. So these 7 principles I mentioned earlier in the GDPR, one of them is that personal data may only be processed fairly, lawfully, and transparently. The fairness and the transparency bit is about doing what you tell people you're going to do in the privacy information. The lawfulness bit is different. So there are 6 lawful grounds for processing personal data. Consent is one of them. Another one is you're undertaking a task in the public interest. If you're a public authority, you might be protecting somebody's life, which is called vital interests. You might be processing data because you've got a contract or about to enter into a contract with somebody. Another one is this notion of legitimate interest, which is in the past been regarded as a bit of a catch-all. It's not quite a catch-all, but if you can demonstrate that the reason why you're processing the data is because you have a legitimate interest, and the processing is necessary for you to fulfill legitimate purposes, then that's a lawful ground. They're not only your purposes, they can be a third party's purposes. So you might get a request for information from the police. The police might say, well, you know, we need it for an investigation. You might say, well, that's a third party's legitimate interest. Or in a lot of our work, we work with social housing organisations. They get requests from utilities companies. Somebody's absconded without paying their gas bill. The utility company says, we want to know where this person's gone, all their personal details. You know, the lawful grounds for the disclosure of that information is it's the legitimate interests of that third party. So the processing has got to be necessary for you to fulfill interests which are legitimate, and I'm using that language carefully because there's a process, a step through to demonstrate that you've assessed it and they are necessary and it is a legitimate interest.
So for a fundraising campaign, how are we going to identify what is legitimate, what isn't legitimate? Is it reasonable to say that there are certain circumstances in which it wouldn't be reasonable and legitimate to send a campaign out, but in others that legitimacy would be increased?
The starting point, which is why I'm astounded that anybody would say direct marketing has got to be done under the basis of consent, is that the GDPR in recital 47 says that direct marketing is a legitimate interest. So you start from that position. You know, are we doing direct marketing? Are we fundraising? Is it similar to? Well, then legitimate interest is going to be valid because the law tells us it is. The thing about legitimate interest is those interests cannot ride roughshod over the rights and freedoms of other people. So you've got to consider, you know, what those people's interests are, and if they've got, you know, if you can demonstrate you've got compelling, you know, grounds that override their rights, and you crack on basically.
So where we do have consent, sorry, moving on to the second. So again, let's look at consent. Therefore, we understand legitimate interest. So what does consent mean? Does that mean, he asked deliberately stupidly, does that mean that someone has ticked a box saying yes, I agree that you can communicate with me and nothing else? Or what does consent mean?
As that's an infinitely more complicated question, I'm going to
right, you got 30
seconds
to answer that one. Okay, all right.
Consent's got a very specific definition within the GDPR that you need to be able to meet. So, for example, in order to ascertain that you got consent, the individual has to understand that they're given consent. They've got to be. Sorry, I'm just twittering a bit now. So they've got to understand consent. It's also got to be given fairly as a consent model. It can't be, there's got to be an affirmative action. So we can't take pre-tick boxes. You've got to either have confirmative action as being a statement, a signature confirming something, or a tick box, but that tick box can't be already pre-ticked, if that makes sense.
Okay.
So under the direct marketing,
someone's got to actually do something to tell you, yes, I am giving you my consent, and they've engaged in an act of something to tell you that that's okay.
But yes, but they've got to understand what they're consenting to. So the consent's got to be granular. So as opposed to just saying I consent to fundraising communications. Well, what do you mean by fundraising communications? Are you talking lottery? Are you talking direct debits? Are you talking events, campaigns? Are you talking joining the raffles and things, for example? So you've got to be quite specific with what you mean in order for the individual to fully understand and know what they're consenting to.
Okay.
So interestingly, Ash, just really quickly, so freely given, specific, informed, that's what consent has to be. I read some guidance from the European Data Protection Board, and they said that waving your phone in a figure of 8 would be considered an affirmative action if that was what was required to demonstrate consent on a mobile app. So it's not just about ticking boxes. This is about, you know, well, what is it we're trying to achieve? Are we specifying what it is? Is this consent freely given, or is it induced, or is it bundled up? And is it informed? People know exactly what it is they're consenting to. And then how are they giving that affirmative action? You're clicking through something, ticking on something, waving their phone in the air, fine. The inaction doesn't count. You know, ignoring a cookie banner and carrying on to navigate a site doesn't usually not count. So it's got to be an affirmative action rather than a lack of action.
Right.
And the obligation and the onus is on the controller to demonstrate that they've got consent. You can't just say somebody's waved the phone at something. You've got, although the European Data Protection Board says that could be taken as consent, the software use will have to note that the individual's done that and has to be able to demonstrate when and why.
On a banana skin.
So from a fundraiser's perspective, so again, we've got, you know, there's a watching this of fundraisers and data controllers and database managers that are saying, right, the practical challenges are, if I'm asking for consent, so David, you were saying you've got to be specific about the consent. Does that mean that when someone is making that affirmative action, let's say it's ticking a box, that alongside that box has to be the exhaustive list of every possible use of that data that you are then consenting to? Or can you say, by ticking this, you're consenting to agreeing to our usage of data and privacy policy, and you can go and find that on our website?
I would say because of the you've got to be specific, and the individual's got to understand what they're consenting to. You're going to have a degree of granularity at the point that you're obtaining their consent. That can be certainly supported by the privacy policy. So, for example, you might say on your consent statement, I consent to receiving appeals. Then within your privacy policy, you explain what appeals are. you might have a consent to lottery and raffles because it's kind of gambling, or in essence covered by gambling rules and regulations. So you could probably club those together as well instead of having them separate. And if you're talking about events, you could probably then explain within your privacy policy, what do events mean? Are you talking mass participation events? Are you talking sit-down events? That kind of thing. So you could certainly support it with the privacy policy, but you're going to have a degree of granularity so they understand at the point of giving you their consent, they know at that point what they're consenting to, as opposed to saying, have your consent now, but then you go off and read it somewhere else in your own time. That means that the consent wouldn't be fair.
And we've covered a couple of things. So the next question that we would have is, what are the alternatives to consent and when they're used? So let me ask again the dumb fundraiser question here to you, the experts. Okay. So what it seems to be saying is that if we ask for consent, there is a fairly detailed and structured process that we all have to engage in to make sure that we've got the right consent for the right stuff and we've explained it, etc. Yeah.
Yeah.
However, all the stuff that we're talking about as fundraisers is direct marketing in some form or other, particularly if it's obviously not electronic, if it's mail. That includes raffle tickets, lottery. Do you want to join the lottery? Can you give us money? Can we talk about legacies, etc., etc.? It's all direct marketing. So therefore, if direct marketing as a function is covered by legitimate interest, why would we ever want to go and bother to try and get specific consent for all these different things if we can just use legitimate interest to cover all direct marketing?
And that's the crux, I think, that a lot of organisations and a lot of fundraising organisations missed at the point of interpreting the law. A lot of them kind of read and went, oh, it's consent, we need consent, we'll get consent for everything. And arguably, if you've got consent and you can demonstrate that you've got consent and your database supports the granularity requirement for consent and it can be managed appropriately, then nobody's saying there's anything wrong with that. But consent has to be managed, and consent doesn't last indefinitely. So then you've got to work through at what point is consent coming up to kind of its termination date, and at what point do we go through the reconsent process, and what does that look like? And if we ask somebody for reconsent and we don't get it, that arguably means you've lost consent, because if they don't respond at that point, then you've not got affirmative action. And so there's a lot of difficulties with it. Whereas for postal communication, so let's just look at DM specifically. Yeah. You can do that under legitimate interest. I would certainly support it in your privacy policy, saying, well, if we're using legitimate interest, this is what we're using it for, and this is and what DM is, and the general campaigns that we might run. Emergency appeals, it could be a raffles, it could be a lottery, and you just bundle it all together within your privacy policy, but in a really, really clear and transparent way. Don't start trying to hoodwink people or use ambiguous language, because otherwise you're actually then delivering a non-compliance with the first principle about being fair, transparent, and lawful with the processing. So if you can use legitimate you can use legitimate interest for direct marketing campaigns. There's nothing wrong with using legitimate interest. As Phil mentioned, direct marketing is classed as a legitimate interest, but because of how the PECR, which Phil mentioned earlier, works, it only really generally works for postal campaigns and telephone, as long as you screen against TPS, CTPS every 28 days as part of the calling campaign. So you certainly can't use legitimate interest for anything that's caught by PECR, such as electronic email communications.
Fair enough. Okay, so let's move on to the next question, because I think that follows on quite nicely. So the next one was asked, okay, so let's imagine a situation, and we've worked with many charities in a situation where they went down the consent route. There has then been either a realization that was a bad decision or wasn't the right decision for that organization, or that decision was made and not implemented properly. And now there's a desire to move from consent back to legitimate interest. Is that possible?
I'll do a summary, Dave. You can do detail. In summary, yes, but you need to have a strategic approach to it. It's not something you can just suddenly switch. You got to make sure. Again, I always say to people, you got to consider that you get challenged on this, and the ICO comes in and says, right, show me what you've got, show me why I did it, demonstrate to me. Demonstrate being the operative word. Show me evidence that you considered this and the steps you went through to move from a consent model to a legitimate interest model. So you can do it, undoubtedly. We've done it with customers, but you need to follow a process, and you need to document, what you're doing, why you're doing it, how you've done it. And I mean, Dave's going to go into more detail on the actual steps to take, but the short answer is yes, but it's not an overnight fix. You've got to take your time and make sure that you jump through the correct hoops and document that you've gone through them. Dave, do you want to cover off on more detail there?
Yeah, no, for sure. There's three kind of steps to take, but the starting point will be looking at data management. So you need to work out what your data is, what your data is, where your data is, how it's been used, and the previous purpose for that use. And any flags that, or indicators that have been applied and why they've been applied, and trying to really understand that point. So it's really, really key that you've got effective data management, safeguards and control measures in place to keep your data accessible. And the reason for that, as Ash highlighted earlier, is the fact that when people come in and make these decisions, say, for example, you're merging the lottery database with the fundraising database, or the retail database with the general fundraising database, people think it's a good idea to put these kind of do not mail flags and do not contact flags on them without actually defining what they are and why they're there. And then the individual potentially leaves the organisation. Everybody looks at that flag and kind of go, we can't talk to anybody. When in essence, all it was there for was to manage a donor journey program, or to manage who communicates with a particular individual. So like from a major donor program, you might have a major donor officer that's working in that role, that wants to keep communications with themselves, with that individual, as a part of a general communication pot. And when you start doing all these kind of do not mail, do not contact, you're really starting to muddy the waters, and that's not really helpful. You will get to a full stop if you identify all the full stops first. So who on your database has said, do not contact me, remove me from your database. There's nothing you can do about those. You might as well get rid of them. You can't reverse that. If somebody's, it's an absolute right to stop direct marketing, so you're not going to get around it with legitimate interest. They've exercised that right. We've got to uphold it. There's nothing.
Can I ask a question at that point, Dave? Okay, so let's imagine, for example, that we're looking at a cold campaign. Okay, so Ash Gilbert is on the database, and I've said to the charity, I do not wish you to communicate with me. Okay, if you remove me from the database and then go and buy a cold list to try and recruit new supporters, and I'm on that cold list, you will then not.
That's a big error, is that? So we as a charity would need to retain your information on our database. The lawful grounds being that, for suppression purposes, so we don't end up putting ourselves in a position where we're breaking the law again. So we would keep your details on there, flag it up as a suppression list, do not contact. So if we did encounter your information again through one of the other channels, then we would know that you've exercised that right. Deleting people from databases is an absolute no-no in database management circles. You've got no idea where you are if you'd start deleting people.
Yeah. And one of the other
but the problem you're up against, Ash, is some of the, well, I looked at DonorFlex when I worked in a charity early 2000s, and it had a do not contact checkbox. Well, what the hell does that mean? If somebody's ticked it, does it mean they've exercised their right, that one of my colleagues is going to contact them? The trouble is, the databases we work with, the legacy systems, just weren't up to the job. And the data we've got is a reflection of, we don't know what questions were posed.
And quite often when that flag has been applied, there isn't then a note that says this is when the flag was applied, who it's applied by, and why it was applied. It's just a box that said don't contact. And you're absolutely right. And there are many occasions that we've encountered where effectively that box has been ticked for thousands of supporters by someone who's then left the organisation, as you rightly say, David. Who knows? And
so everyone moved off this onto preference centres at some point in the mid 2000s. Where you had a complexity of contact preferences, channel preferences, and so on and so forth. That added another degree of complexity. But these simple tick boxes are just they're just hard to work with now.
I'm going to move forward to the next question because it's aware of the time, guys. So we're going to try and get through all these questions. So just again briefly, you talked about PECR. So we have to use consent for electronic marketing. So there's no such thing as legitimate interest for electronic communications.
You have to use consent. You have to have prior consent for unsolicited direct marketing sent by email.
Okay. So if someone signs up to one of my fundraising events and gives me their email address,
that's not good enough. So the unsolicited solicited means specifically asked for. I want you to send me information about this service, product, whatever.
Okay.
Unsolicited means not specifically asked for. So signing up in general terms, for marketing programs isn't good enough for PECR.
Okay, so for electronic communications, there needs to be clear and explicit permission given at the point of entry that we will retain your email or your phone number, whatever we're going to be using, and we're going to be using it for this, and we ask you to confirm that you're happy with that. Yeah,
the definition for consent in PECR actually refers to the GDPR. There's a section within PECR that says any undefined terms and are defined in the Data Protection Act or the GDPR will be the defined terms within PECR. So where PECR relies on consent, it expects now the consent to meet the requirements under the GDPR.
Okay, so in practical terms for a fundraiser, where it is possible to use legitimate interest to send a direct mail pack to someone saying, this is us, this is you, we're asking for money, you cannot use the same justification to send an email campaign out.
No, you can't use legitimate interest for email marketing. The rules are quite clear on that within PECR. Likewise, just be very careful if you're going to try and increase or email people saying, have we got your consent? Because again, the ICO is quite clear with the cases that they've found against organisations saying the asking for consent by email is marketing in its own right.
Okay.
So if you want to try and increase the number of permissible emails on your database, your only option initially will either be while somebody's talking to you and you're engaged with you at that point, or through DM.
I just seen a question flag up, which is well worth pointing out. So we're talking about business to consumer emails. So business to business emails are less stringently regulated, and you don't need consent. According to the new guidance that the ICO has published, you do not need consent to send unsolicited direct marketing by email to businesses, to a business email address. Again, there's a bit of ambiguity there. Everyone assumes business email address being sales at, dataprotectionpeople.com. But, the interpretation seems to be that, philip.brining@dataprotectionpeople.com would also be caught by that business flexibility. Yeah, because it's and if you think about it, whilst it still is intrusive, it's not quite as intrusive as it is on a business to consumer perspective.
Okay.
I would also say that that's nuanced as well with making sure it is a business. So some small traders, maybe trading under a personal email address, will be a personal email address.
Yes, correct. Sole traders and partnerships are classified as individuals, where limited companies and organisations of that nature are considered to be legal entities.
Employees of limited companies would be considered as a business recipient, effectively, of that communication, rather than an individual. Okay.
Correct.
All right. So there's a difference there between those two. Again, let's move on. So here's I think one of the key questions, right? These are the challenges that we're often faced with. Can we re-engage with a supporter where we no longer have consent to contact? So from that, I'm thinking that where we've had a consent policy, where that policy, for example, says we think it is reasonable to talk to you about fundraising for up to 3 years, or commonly 3 years, we find, after your last donation. But now we're in the midst of a pandemic, and suddenly charities realize that actually, no, I want to be able to go out and communicate with many more people, and this is what we've been working on, and we've seen the results that come through that. So can we, where consent has lapsed, can we re-engage? Or, and I think, David, you probably already answered that question, where they've expressly asked for no contact, seems that no, that's a hard stop. Where there's been an expressive thing to say, do not contact me, that is immutable. We cannot change that. But how can we re-engage the supporters where consent has lapsed, either through inaction or something else? How do we get that? How do we get that communication going again?
You can certainly unpick consent from a DM, so from a postal point going through. As I say, you need to understand what the flags were there and really understand before you start picking them. If we can identify, is it an absolute stop that I've come against, or is it a flag that we stuck on the database for some reason that nobody really knows about, firstly? So you need to understand what you're looking at and why you're looking at it. If the flag is an internal measure, for example, you restricting people talking to major donors, or it's this flag to stop individuals communicating with the lottery players, for example, because there's a tension between sending appeals and lottery players. That's just that's kind of an internal measure. And so once you've understood that, then you can get and justify why you're looking at removing that flag. Then you can go through the steps that we discussed previously about making sure that you've updated your privacy policy. You ensure that your privacy policy and your data collection statements are compatible with each other, so there's consistency of message. You've gone through your legitimate interest assessment, and you've detailed why you feel you've got a legitimate interest, why you've balanced the necessity of being able to communicate with somebody with the individual's rights not to be communicated with. And there's a whole range of things you can do around that. So, for example, as you're trying to demonstrate why you've got a legitimate interest, you might kind of say, well, actually, we've got a legitimate interest, but what we'll do is we'll manage the mailing return. So if we get a no to mail return to sender, we'll take them off. We won't communicate with them. That's in essence
And I think the crux of this, though, to me, is can we re-engage with the supporter via email, unsolicited direct marketing, where we no longer have consent because it's lapsed? If we've had prior consent, but because of our own internal policies, it's lapsed. That to me is going to be the crux of this question, and the lawful grounds in the past were, well, consent, you have to have consent. It's whether or not it's fair to then, say, well, we're changing our policy, and we're not going to lapse consent automatically after 3 years. We're going to not lapse it at all. There's a tension with retention policy there, but that, what's your thoughts on that, Dave? Because that has to be the
Can I just ask? Sorry, Dave. Just before I just give you an example, from a fundraiser perspective, looking at that again, we commonly find a privacy policy that says 3 years, and that's it. So if you've given us something within 3 years, then it's okay for us to communicate with you. But if it's outside 3 years, it can't. And in every single database we see, we will find a donor who gave £5 35 months ago and nothing else, and they fit the policy. And then there is another donor, and this is replicated hundreds and hundreds of times. There's another donor who hasn't given for 37 months, but they've been supporting the charity for 20 years before that, and they've given thousands and thousands and thousands, and suddenly they're not in the policy. And the privacy policy, the legitimacy, the length of time, I think the most interesting one, it seems to me there doesn't need to be, how do I say this, a lot of logic involved. The Dogs Trust, as I understand it, and I think I'm right, this is what I've been told, the Dogs Trust's privacy policy states that we believe it's reasonable to continue to communicate with you for up to 17 years after our last engagement, because that's the average lifespan of a dog. Well, now, is that a reason,
The key to this is kind of, I think people get mixed up with data retention, and data retention basically says you can retain data as long as it's necessary. So again, if you've got a case for why it's necessary, then and what you have to put in your privacy policy is either the time period or the criteria under which you can retain data. So the mistake is to put 3 years. The smart thing is to put, as long as we find it, worst effective, as long as we find it useful to retain your data, as long as it's, So people putting in hard-coded time periods is just, it's suicide. You shouldn't.
I think just quickly on that was on the 3 year there point, Ashley. I think some of that's possibly come from a misunderstanding as well within the law, because the legitimate interest doesn't say you've got to have it time bound. The legitimate interest is, have you got the legitimate interest, and can you demonstrate that? Where the time element generally comes in is because the ICO says consent doesn't last indefinitely, and therefore you've got to determine how long consent lasts for before you go through the process of reconsent. And I think what you've probably got there with some organisations is this kind of mismatch between, well, are we consent, are we legitimate interest? Well, actually, let's just say we'll do it for restrict ourselves to a time period, because we really don't know what we're talking about.
But the key is, again, if you've had regular communication with these people, and on every occasion you've given the option to opt out, they haven't opted out, I would say, well, that is refreshing that validity of the consent. Yeah, so again, we can document these arguments. If we get challenged, we can then present the facts. And this is our approach. This is what I would take this approach. This is how many times we've communicated with this person, and they've never chosen to opt out. These are the open rates of our emails.
Absolutely. You look at your lottery campaigns or your direct debits and bits and pieces that Ash's team might put out through the door. When you've got somebody on a regular giving program, you generally look at around about a 5-year program. Some will say a lot longer, but you generally look, if we get direct debit, on average, it'll last about 5 years. So if they're paying every month, year on year, for a minimum of 5 years, as a kind of the stats kind of show that, then you could argue you've still got a relative or a relevant relationship with the individual, and still quite entitled to talk to them through DM, through legitimate interest, without hamstringing yourself to 3 years.
I'm going to move on to the next. I'm going to move on to the next slide, guys, because we need to get cracked on. But this is the key one, right? And we have worked with a number of charities in this situation. We made a mistake. So to give you a practical example, so one of the charities, Director of Fundraising, has recently taken over. Their predecessor implemented a consent model with a time limit, but then, as far as it's able to decide, didn't actually then engage in any activity to go and get consent from anyone at any point, and then left the organisation. So the organisation is now left behind with, we have to have consent to be able to communicate with you, but no one went and got consent from anyone. And again, what do they do? So if we've made a mistake, as you've said earlier, Phil, if we've gone down a cul-de-sac, how can we rectify that? Is it reasonable to turn around and say, that was wrong, we made a bad decision, or we didn't implement it correctly, we need to effectively, go back in time and say, right, we're gonna make that decision afresh and ignore the decision? Or are we locked into the decision?
You're not locked in. So as I said earlier, you need a plan of action. Yeah, so you might admit internally that you've made a mistake, but externally, the key is to, as Dave said earlier, understand what you've got in your database, but then put in place the plan to get out of this, which is the processing has got to be fair. So you've got to tell people that you're gonna to change. You don't have to say we've made a big mistake. You just say, well, this is new privacy notice. We're processing for direct marketing purposes on the basis of a legitimate interest. You've then got to think, well, if we get called in by the ICO, how are we going to demonstrate that we've communicated this adequately? So we've done a website, we've put it on the back of envelopes, it's on the franking stuff. Whatever you've got, a leaf that goes out. Every email's got this. So you can demonstrate we did everything we could possibly to raise the change of our approach with people. So that takes time to work through, and depends on what channels of communication you've got and the relationship and like that kind of stuff. So you can definitely get out of it. It's really hard to get out of. We haven't got consent for email marketing, and we want to do email marketing. You completely in the cul-de-sac.
One of the charities that we worked with a few years ago, again, local regional organisation, who had a team who had been there 25 years. They'd always done it the same way. And when we just went to work with them, they had one database, which is a huge list of individuals and companies, and a large number of email addresses. And most of their events fundraising was taken through email addresses. There was no consent in place at all. There never had been. They'd never thought about it. They'd never asked for it. And then GDPR had come in, and suddenly their entire fundraising model was based on being able to email people to say, do you want to take part in this stuff? And so their choice was either we continue to email people who, and let's be honest, in that situation, were entirely comfortable with that because it's what they'd always had. There was no abuse of data, but legally they didn't have a leg to stand on. And in that situation, their decision was we're going to carry on because otherwise we fold. But we are now going to start gaining. So that very thing that you said, emailing to ask for email permission, that's what they were forced into, because the alternative was literally to fold the charity.
The ICO's taken action against 2 organisations for emailing to obtain consent, but that was very much unsolicited direct marketing. It wasn't in the context of charitable giving. So, it is a compliance risk. You got to recognise that. But if that's the only option you've got, then
but again, as you said, it's about reasonableness. If that charity can document and demonstrate that actually work should have been done, action should have been taken earlier, it wasn't. We're now in this situation, and we, as you say, we are non-compliant. In that case, they're incredibly non-compliant. But in order to be able to continue the organisation, we have to continue being non-compliant, but we will work towards compliance. Is that reason? Again, is ICO said that they are comfortable that as long as I mean, I'm not asking you to put your neck on the block and say, right, this is yes, you can go and do this. But again, is it reasonable if there are a reasonable pathway and a strategy in place? Is that okay?
No, it's still a compliance risk until you get to the point where you can demonstrate you've got consent to send emails for direct marketing unsolicited. Then it's a compliance risk, and the ICO will take action despite you saying, well, we've got all these great plans in place. They'll say, well, I'm afraid you're still not compliant. Sure. But you've got, running any business is about managing risk, isn't it? So you've got to use all the channels available to obtain repaper consent, as people would say, obtain consent. Ideally low risk ones like direct marketing. Phone calls, person-to-person live phone calls, as Dave said, is not as stringently regulated as long as the people aren't on the telephone preferencing service. So you could have a phone campaign to obtain consent. You could appeal to people's better judgment and email asking for consent. But you recognise that is a compliance risk. Doing that, emailing out, asking for consent is a problem.
All right, let's move on to, we've got a few more questions to cover before we get to any questions that are coming as we've been going. So again, if we need to ask again for consent, the supporter doesn't respond, does that mean that's it, game over, we can't communicate? Or again, are we back to using legitimate interest in that situation, as long as we've explained that's what we're doing?
I would certainly make sure that you've got a plan of action to address this, because the definition of consent is that you need affirmative action. So if you've asked somebody for consent and you've not got that affirmative action, then arguably you failed the test for consent. Yeah. So if you're going to go through that measure, I would either have a plan of action to go, well, actually, shall we move away from consent at this point, as we discussed, and take the appropriate step. So then you're not in that kind of muddy water of, well, can we, can't we? Because arguably you need to demonstrate that you've got consent and consent meets the requirements of the GDPR. If they don't respond, you've not got the affirmative action.
One of the challenges I think that, again, charities have and us fundraisers have, I was with one of our clients working with a group of their ambassadors who were individuals who had agreed to use their personal networks to go and raise £100,000 per year for the charity. And they would do various, events and dinner parties and that kind of thing. So I was leading a meeting of these guys. And one of them turned around and said, you know what, I haven't had anything for about 18 months now. It's really weird. And it was then we talked through, well, it's a consent model. You've been asked for your consent. And he hadn't consented to communication, so they'd have to stop communicating with him. But he, as an ambassador who'd been supporting the charity for years and years and years, didn't realise that he'd been asked for consent or what it meant or that it was important, etc., etc. And so there's I think some of the frustration from the fundraiser side is actually the vast majority or a significant number of the people that we're actually talking about haven't the faintest idea what we're talking about and are completely fine for us to communicate with them and ask them, because of course you would. We've been supporting your charity for years. So
And these are all the problems that you get with the issues of actually trying to obtain consent, because if you don't get consent and it doesn't meet the markers, then arguably you've not got it as per the definition. However, as you've indicated, supporters might go, well, I need to respond to that, put it under a pile of paper, never get round to it because of inertia and just general life getting in the way. So they've intended to communicate, but they've just not sent the mechanism back to demonstrate. So you've got something that you can demonstrate where you've got consent. So arguably you don't meet requirements for consent. So it comes back to the very crux of this discussion really is, why the heck are you using consent when you don't need to?
Absolutely. Well, that's the same. It seems to be really clear that actually for direct marketing communications, we shouldn't be using consent unless there's a specific and absolute and really important reason why we're doing that. We should be freeing ourselves. We should be doing the dog's trust and saying, actually, there will be times when we need to communicate with you, and we will use that. So where it's legitimate under these, and this is our terms and definitions, and there's our privacy policy. So effectively, we should leave ourselves open to be able to communicate, because if we have a charity, and if literally the roof does set on fire, then we do need to be able to reach out in a much more urgent and greater sense, and that would be a reasonable understanding and use of that data. It does not mean, I think this is the other misconception, it doesn't mean that fundraisers are now looking to bombard every supporter with every little bit of paper we can possibly find as much as we can because the law says we can. It's never been about that. We want to have that donor journey. We respect people that have there's a certain longevity, and for us, we're not going to continue mailing for years and years because it won't be profitable. We'll if someone's given a small amount of money once and then doesn't give again, we'll stop communicating because we don't want to keep spending that money. But we do want to leave the door open that, for example, if a global pandemic were to happen, we've got the tools and the mechanisms to be able to reach out and say, actually, guys, this is a real problem and we need you to come back and help us. So is that reasonable? Again, that's kind of where we're looking at.
Absolutely. That's actually getting to the two crux points. There's two main points that we discussed today. One was data protection, how can we do things compliantly? And the other is, do you actually know, not from using Pebblebeach, because this is your areas of expertise, but within individuals within the charities, do you actually know the art of direct marketing? Do you know who and why and what you're contacting people for? And do you know how to maximize that and get the best returns? And do you keep people on a journey so they're there for the longevity? That is all the art of direct marketing, which you guys are really, really good at. But so the understanding from the charity is, do you understand direct marketing and all the bits that is in the science of that? And do you know and do you know data protection? And do you know how to bring the two together for the very reason that you said, let's keep the database as accessible as we can unless we hit those full stops. And where we hit those full stops, we can't go any further.
I'm going to whiz through because the next couple of questions we've actually covered. So we talked about using soft opt-in for direct marketing communications. We talked about legit interest. We've talked about unsubscribes from a fundraising email. Can we contact them again? We said no because that's PECR. But the last one I think is really important. So this is something that's really important for now. So here we all are sat mostly in our homes, staring at each other on screens. Fundraising teams are working remotely. We are talking to each other. We are sharing, we are accessing our databases remotely. We are sharing mailing files between each other. We are talking to each other about this particular donor and what should we send them or what should we invite them. How does this working remotely, what challenges and problems does that present, and how do we meet those?
Mostly security, aren't they?
I was going to say, the law doesn't say you can't work from home. The law just says you need to understand the risks of your activities and to mitigate them accordingly and to demonstrate that you've mitigated them. A lot of our clients are working from home. If a lot of our clients are working from home with organizational supply devices that link to the network through a Citrix environment, VPNs and all the security and monitoring around it. So in essence, the working in the workplace as a normally access stuff, but from home.
They just have
The difficulty slightly comes is where you're asking individuals to use personal devices. because then there might be information on a personal device that relates to the organization, either commercially sensitive or relating to individuals, data subjects and stuff. And again, it's not necessarily saying you shouldn't do it, but it's knowing A, what you've done in order to make people work, enable people to work from home, and B, how do you unpick that when you go back to the office, and how do you make sure that you've mitigated all the risks to the data subjects, to the organization, should you get a wayward employee, and how do you get that information back at the end of the day? Yeah. So you've got to do an appropriate risk assessment to go through each of those steps through there to understand what the risks are and to mitigate them accordingly.
Because it's likely we're all going to be working from home for a good many months, if not longer than that, and anyway, so we need to be aware of this. From an agency perspective, I think that one of the challenges we have is that we use a secure online file sharing system, which is fully compliant with GDPR, et cetera, and everything is locked and password and access. There's the security behind that. So obviously we need to transfer information and data between that. But on a reasonably regular basis, we will have one of our charity clients email us a list of donors to look at, and it won't be passworded. It will literally just be an Excel attachment in an email. And so again, I think that the challenge for many fundraisers working from home is that the rules still apply, and therefore, although it is difficult, and although it means that we have to go through a certain process and use secure systems, it's absolutely crucial to do that. It's absolutely crucial to do that, because even though for us we're only sharing mailing data quite often, we wouldn't be sharing, for example, credit card information or anything like that. We're still sharing private information, and that must be done in a secure fashion.
And that could actually be sensitive personal data or special category personal data if it's a specific charity. And we saw a list of HIV patients sent to the wrong person a couple of years ago, didn't we? So just a list of patients, but the way it was being sent implied that these people were infected with the virus. With the kind of use of shared devices, I use Mr. Tumble. If you've got the kids sitting down watching Mr. Tumble on the laptop you're also working on, is that good practice? You've got shoulder surfing where people are standing over you. You don't know what environment people are working in terms of their household. Is the machine they're using properly patched? Does it introduce vulnerabilities to your network because it's not properly managed? There's been a massive increase in spear phishing because the remoteness of people working means that they're much more vulnerable to being spammed and clicking on spurious links. But you kind of use it error. Emailing a spreadsheet to the wrong person is the same in the office environment as at home. I mean, that doesn't change at all.
Yes. Exactly. So it's the same. It's exactly the same process we got from that.
Yeah. But I have a client who says in a workplace, Control-Alt-Delete if your bum's off your seat. And why would that not apply at home?
Absolutely. And then all the training that I deliver as well with my clients and a range of other clients that we have, I often really try to drive home the fact that your policies and procedures in the organisation aren't bricks and mortar bound. They apply wherever you work, whether that's in your home office, whether that's on the bus or the train on the way into work, whether it's because you've gone and sat down Costa Coffee for half an hour and you thought you'd just jump on and answer your emails. The policy procedures around acceptable use and what you do and you don't do apply to your working environment, not necessarily just bound by bricks and mortar.
Yeah, doesn't matter where you are. Okay, that brings us to the end of the questions that we pulled together. Chelsea, do you want to pop up and say hi if you're there? And is there anything else?
Today, Ash, I'm afraid.
Oh, Amy, sorry. Oh, Chelsea's internet died.
Well, no, it was always me, but that's cool.
Okay. All right, how you doing? So, Amy, what have you been seeing on the chat? Is there any kind of common questions that come and go? I have to say that if there's anything specific to you and your charity, that's absolutely fine. We'll deal with that after the webinar, and you can get in touch. If it's a fundraising thing, you can talk to us. If it's a data protection question, you can talk to Phil and David. Yeah.
Okay. So I mean, we've had a lot of questions about legitimate interest and consent, sort of in conjunction with each other. I think because we've kind of covered a lot of that within the webinar, I think it might be useful. So I've got a question here which said, we're currently using an opt-in model to communicate with supporters, but wanted to hear thoughts about moving back to legitimate interest model. It seems to me those aren't mutually exclusive, but maybe it would be, if you could you talk through maybe the steps of you've taken that step, you've said, oh, we're only doing opt-ins. Now, how do you kind of get yourself back to a middle ground where you can do both? Can you guys talk through that?
Yeah. Sorry, Phil, were you going to say something? Or you?
No, I was going to let you start off.
No, for sure. It comes back to what we were saying earlier. It's firstly, you need to understand what your opt-ins are telling you, what your opt-outs are telling, and you can certainly unpick consent going back to legitimate interest, but you need to understand what you're looking at and why you're looking at it, and the what you told people at the start, what the flags mean, and what's available to you. You also need to be able to identify which are the full stops and how you take those out, not necessarily deleting from the database, but certainly making sure they're not within your mailing file. That goes off to the printer mailing house or used for your direct marketing activities. You then got a little bit of data governance to kind of go through, data protection governance. So you need to review your privacy policy and make people aware that your privacy policy has been changed, to demonstrate that you proactively try to tell people. That's not the same as actively putting a copy under everybody's nose, because the activity of direct marketing is already within your privacy policy. You're just moving from consent to legitimate interest. But you maybe, as part of your defence or as part of your justifiable position, is we've made it prominent on our web page for a period of 4 to 6 weeks. We've added it to our newsletter that was going out to tell people that it's updated and where they can find it. We've added it to the back of direct mail campaigns on the outer envelope saying our privacy policy is updated. If you want to review it, please go www. Privacy policy, that kind of thing. So you need to go through that kind of due diligence measure to demonstrate that things have been changed. You'll also then, in order, because your privacy policies change, make sure that your data, make sure that you either where you're trying to get consent for email marketing and legitimate interest for postal communications matches what you say in your privacy policy, and then can be achieved on the database. Don't certainly start hamstringing yourself trying to get a range of different methods and a range of different elements where your database just doesn't support the recording of that. So you need to work out what and when you can do it. Once you got yourself to a position of we've got the data, we know that we can actively communicate that there's no full stops in these data, this data that we've got, you're then going to have to do a legitimate interest assessment to demonstrate why you feel you've got a legitimate interest and how that interest is balanced against the rights and objectives of the individual and what that might mean, and all the measures in there, whether it's the fact that we'll manage mailing returns. For anybody that says return to sender or do not contact me, we take them out of future mailing files, leave them in a suppression file, for example. Or you go through assessing, and Ash can certainly help you with this, assessing the non-responders to your campaign to work out, well, we've sent them, for the last 3 years, we've sent them raffle packs, and every year we send 2 raffle packs out, so arguably they've had 6. They've not responded to any of those either of those 6 packs, so therefore the chances are they're probably not that interested in raffles. So there's bits you can do to kind of manage that around that from a really effective direct marketing point. And then when it comes to actually using the data and relying on legitimate interest, you've got to make sure that you've excluded all of the full stops. You've got to make sure you've excluded your suppression files, and if necessary, screen against the mailing preference service, take all the gonaways and deceased records out by using external records for data cleansing, shall we say. Especially where you might have some really old data and you're not quite sure where it's come from, but potentially it's still contactable. Because if you're writing to people who've gone away or deceased, then it's going to affect your costs ultimately. So you want to try and use the cleanest data. But
what you're saying there, David, again, is the general point I think is worth repeating, that we're saying that charities do not want to exploit vulnerable individuals to try and sort of get money out of them. What we'd like to be able to do, particularly in these times when we have an urgent need to communicate, we want to have the ability to reach out and connect with as many people who reasonably might be interested in supporting this. We're not going to spend money where there's no chance of getting money back in, because that's not what we do anyway. But where there is a likelihood that that individual would welcome a communication from the charity and would welcome the opportunity to have the chance to make an informed decision about whether or not to respond, we'd like to give them the chance to do so. And the way to achieve that, even though we may have been hamstrung by having consent options or privacy policies that restricted us in the past, there is a pathway, there is a structure, and although, again, there is complexity to that, actually that can be engaged pretty quickly. It can be delivered as long as, again, 4 to 6 weeks, it's shown with, look, we changed the privacy policy, we've adopted the new rules, here's why we put the new rules in place, here's the justification for that, here's where we told you, we've then communicated with you that these new rules are in place, and let us know if you'd like to change how we communicate with you. But once we then get to that point, we are then free to be able to reach out to a wider audience if we want to do that, because we've gone through that process. Yeah, so there are ways of reversing out of the culture.
The more you can add, just 4 to 6 weeks is a guide. So if web traffic is very, very negligible, then 4 to 6 weeks isn't really cutting the mustard. The objective is to demonstrate that we've done what we can to tell people the policy has changed. So if you did a focus group with some client, some donors, we're going to change this, what do you think? That's adding value to your credibility, to your justification. Splash page, if you've got a website people log into, I don't know if you've got like a lottery and people log into that. If you put a splash page, people click through. It's a way of informing them and also demonstrating they've seen it because you've got evidence, recorded in the database. The RNLI famously did a radio campaign, didn't they, to kind of make people aware of their changes. So the more you can do to add value to your argument, we've done this, what more could we have done, is really what we're trying to achieve here. So technically not a problem. The devil's in the detail. What type of relationship have you got? What type of communication channels have you got? And how have you exploited those to get the message across that the lawful grounds have changed?
Thank you, Amy. Anything else that you think we should be covering?
One quick question for Phil and Dave. Are we going to be able to have all these FAQs with answers supplied?
We can do that, can't we, Dave?
Yeah, we can do that. Yeah, that's no problem.
Yeah, every charity is individual, and you've all got individual circumstances and challenges behind that. I think that we as an organisation, we found it extremely useful being able to work with DPP to help us through our journey to be able to get to the point where we're comfortable, that we're compliant. Again, I mean, David, when you came and you looked at us, we weren't fully compliant. There were things that we weren't doing properly, and we've changed. We changed, and we'll continue to do that. But again, that's that working process. But certainly, I think that our conversations with fundraisers and data controllers at charities is that it could quite often GDPR can seem to be this massive wall that stands in front of you, and there is this threat of legal actions, hundreds of thousands of pounds worth of fines if we put a single step out of line. And I think what we've talked about today is that is not the case. It is just simply there. It's a framework, and again, there is a pathway of reasonableness, of taking proactive action that can change the situation moving forward. Yeah,
it needs to be respected. It is the law. Yeah. So we've tried to paint a picture of it is entirely possible to move from one model to another. What we've said is you got to go through a structured approach. If you get it wrong, you will get regulatory action taken against you, which might involve fines, it might involve enforcement notices. One of the things to be very aware of is that people have got right to compensation within the law. So if you lose a database of 1 million people and they come after you for £100 of compensation each, and the going rate is more than £1,000 for these compensation, no win, no fee law firm will jump on it and will represent these plaintiffs. So compensation is a silent kill in all this. If you get it wrong, the ICO is not necessarily the problem here. The problem potentially is no win, no fee lawyers. And if you Google data leak lawyers, you will find them representing for one of Dave's clients, victims of a data breach from one of our housing clients, British Airways, Marriott Hotels, Carphone Warehouse. They've got no scruples. They'll come after you, I think.
And to explain, obviously not going into the client too much, but that it was just human error. Really, there's a little bit of a processing around. Do you understand the processes and that kind of thing? But it wasn't an intentional thing. It was just human error. Ultimately,
that's why that structure and process of how we communicate and share information. We've got to have the structure in place. Guys, we're going to wrap that up now. I'm just going to quickly share screen with this. So again, we are here. We're quite happy to try as best we can to answer any questions relating to fundraising, and to walk through how we've been able to help clients through this pathway of moving from consent into legitimate interest, and essentially freeing some of the restrictions that allow wider communication. Our details are there, but we're our website, pebblebeachfundraising.com, all contact details there. Get in touch if you'd like to. hello@pebblebeachfundraising.com for us. Phil and David, contact details there, and I know that you guys are speaking to organisations and charities every day of the week anyway and answering questions. I know that you're very happy to share that. So if we can have, again, if we were able to provide as part of the output from this, we'll put this video up on our websites. We'll make sure, obviously, if you've got those simple FAQs with concise answers to that, I know you've already got that, and provide that. But ultimately, it's about trying to give everyone the opportunity.
To support that, I would say don't get yourself stuck in a hole. If you're not sure, it is okay to ask. Just reach out and talk to them.
Yeah, absolutely. Complete message. Don't worry about this stuff. There is a solution. It might be some work, but it's not all lost, and there is a solution, and there is opportunity for you. Guys, I'm going to stop sharing now. So I hope that was useful to everybody. Sorry, I went on a bit long. We've yet to do a webinar that's actually stuck to time, so sorry. And we could have told you that at the start, to be honest with you. Hope that was useful for you. Hope you've got something that's benefit for you that you can take back to your charity. But don't be shy. Come and talk to us. Come and ask the questions. And I hope that what you've heard today gives you that confidence that if you have got a problem around data control and policy and GDPR, you've started to see a pathway forward from that. So we're going to say goodbye. Thank you very much. It was lovely to see you all. Thank you very much for giving you time. Really appreciate that. Thank you so much, and we'll catch you soon. All the best.
Thank you very much. Thank you.
Bye.
Take care.
Cheers, Dave. Cheers, Phil. Appreciate that. Take care now.